You're listening to the Cyberwire Network, powered by N2K.
Hilton brings you new ways to stay, with experiences that let you capture the glory days. Introducing the Graduate Hotels. Each inspired by local college towns, these stays are always original and never boring. Get in touch with traditions all across the country and enjoy a stay that's a class above the rest. Book at Graduate Hotels with Hilton Honors Points at Hilton.com. It's a win-win. Hilton, for the stay.
Hello, everyone, and welcome to Caveat, N2K Cyberwire's privacy, surveillance, law, and policy podcast. I'm Dave Bittner, and joining me is my co-host Ben Yellen from the University of Maryland Center for Health and Homeland Security. Hey there, Ben.
Hello, Dave.
On today's show, Ben discusses an en banc ruling from the Fourth Circuit on geofence warrants. I've got the story of a judge giving Apple the business over failing to obey an injunction. While this show covers legal topics and Ben is a lawyer, the views expressed do not constitute legal advice. For official legal advice on any of the topics we cover, please contact your attorney. And now, a word from our sponsor, Black Kite. If third-party risk is keeping you up at night, you're not alone. It's a constant battle. Black Kite's third-party cyber risk platform is built on real-world threat intelligence, straight from their research team's ongoing breach analysis, dark web monitoring, and attacker tactics. That means you get a hacker's eye view of your supply chain to proactively spot risks. And speaking of research, they just dropped their 2025 third-party breach report, breaking down last year's biggest trends and what's coming next. Grab the report now at www.blackkite.com. All right, Ben, we've got some interesting stuff to cover here today. You want to kick things off for us?
Sure. So we've been talking about this case on geofence warrants for a long time. It's called the Chatrie case. To sum it up in a sentence, guy robs bank. Law enforcement in Virginia obtains a geofence warrant, does a bunch of investigative work, realizes that this guy Chatrie was in the area. He's arrested and prosecuted. So we have a district court opinion. It goes up to the Fourth Circuit Court of Appeals. They come down with a decision, and then it went to what's called an en banc panel on the Fourth Circuit, which means generally, at first blush, a case will come in front of a 3-judge panel. Mm-hmm. Fourth Circuit has something like 12, 13 judges. So en banc means it goes in front of the entire panel of judges. So you got a diverse array of judges appointed by presidents of different ideologies, so they disagree on a lot of stuff, and that's exactly what we got here.
What triggers it going in front of the bigger group?
So usually there is a motion to rehear a case en banc from the losing party. So the 3-judge panels are purely luck of the draw. I don't know exactly what the system is. It's drawing straws or popsicle sticks or something. So that's completely random. So let's say you have, out of 12 judges, 8 judges appointed by Democratic presidents, 4 by Republican presidents. You could still get a luck of the draw where 2 of the judges are appointed by Republicans, 1 is appointed by a Democrat, and that means if you lose the case, you might think that you have a better chance just given the ideological makeup of the full court of winning the case en banc, if that makes sense.
Okay, sure.
So the majority opinion here is very short. It's pure curiam, meaning it is just the opinion of the court. And it says that the judgment of the district court is affirmed. Great.
Well, I'm glad we went through that effort.
So let's move on to the next story.
Right.
Unfortunately, that is not the end of our concerns here. So the decision of the district court is upheld, but we have something like 8 different opinions authored by a variety of judges offering their own perspective on how geofence warrant cases should work. So I'm going to kind of quickly summarize. This comes from an article from sometimes friend of the podcast, Professor Oren Kerr, now with Stanford University at the Volokh Conspiracy blog on reason.com. So there are 8 separate opinions, and I'll kind of go through what each of them are and then maybe give an analysis of where I am and what this means going forward.
Okay.
So Judge Diaz, writing for himself, wrote that the good faith exception applies in this case, so they should not reach the merits of the Fourth Amendment issue related to geofencing. So a reminder that a good faith exception means that if law enforcement didn't know that courts might hold geofence warrants unconstitutional and they were operating according to a reasonable understanding of the law at the time they completed the investigation, we shouldn't punish them for that. In other words, if a criminal is convicted, they should still be convicted.
Right.
And according to Judge Diaz, the case should end there. They don't have to take up these complicated issues of whether geofence warrants are constitutional. In this particular case, on a narrow issue of whether law enforcement was acting in good faith, they were. That means the conviction can be sustained.
I see.
Separate opinion issued by Judge Wilkinson, who is a Reagan appointee, joined by Judges Niemeyer, King, Agee, and Richardson, claimed that geofencing does not count as a search, and they rely on what's called the third-party doctrine, which we've talked about a number of times. Basically, you are willingly, voluntarily disclosing your location to Google when you're using an application or when you're using Google Maps or whatever. That means you lose an expectation of privacy in that data. If a person does not have an expectation of privacy in that data, it is not a search according to the Fourth Amendment. Therefore, a person doesn't have a Fourth Amendment right inherent in that data. So they would just say this is a simple third-party doctrine case. Judge Niemeyer, in a separate solo opinion, said that no search occurred here because the government was just following tracks left by its users, which is not a search. Judge Niemeyer also relied on the good faith exception. So what does Judge Niemeyer mean by following the tracks left by users? Imagine like you're walking out of a bank and you have a chocolate chip cookie crumpled up in your pocket.
Let's make it easier. It's been snowing.
Yeah, exactly. And there are some very convenient footprints on the ground that match the Bruno Malley shoe
Right.
that our criminal suspect was wearing.
Right.
Judge Niemeyer is basically saying that's what happened here just in the digital realm. Somebody's left these breadcrumbs. Law enforcement is following these breadcrumbs. That's it. That should be constitutional.
Okay.
Another judge, Judge King, who I believe is an Obama appointee, said that this is a good faith exception case, doesn't go beyond that. The really interesting opinion came from Judge Wynn, also an Obama appointee. Judge Wynn was joined by Judges Thacker, Harris, Benjamin Berner, and for the most part, Judge Gregory. And they claim that geofencing is a Fourth Amendment search, that we have to look at this in the context of Carpenter. Carpenter, in their mind, was a transformative decision. It replaced our previously existing theory of the third-party doctrine and announced these third-party records cases are more multi-factor tests. So in Carpenter, the test was about the depth of the information collected, the breadth of it, and the involuntary nature of the collection. And when they apply those factors in this case, as it relates to geofencing, they claim that it is a search. They also are willing to admit that the good faith exception applies, so the government wins anyway. But for all other geofence cases going forward, this would count as a Fourth Amendment search because of the depth of the information being collected, the breadth of the collection, and the involuntary nature. We have Judge Richardson, joined by Judges Wilkinson, Niemeyer, King, Agee, Quattlebaum, and Rushing. I swear I'm not just making these judges up.
It does sound like names of law firms. So.
It does. It also sounds like ChatGPT elucidating about the case.
Right.
They argue that the government wins under the third-party doctrine, that there is no search here. They agree that Carpenter limited the third-party doctrine, but under Carpenter, the rationale of the third-party doctrine applies because the information here is limited and was voluntarily disclosed when users opted into their location history feature. So in the Carpenter case, it was about historical cell site location information.
Right.
Your voluntary action in that is turning on the device.
Yeah.
As opposed to I want to turn on my location. Hint, hint, nudge, nudge. The person should realize that somebody is going to be tracking that location and they will be using it against you. We have Judge Haytons, joined by Judge Harrison Berner. Whether or not a search occurred, good faith exception applies. Evidence is admissible. I don't know why they have to have separate opinions. There are 3 separate opinions basically just saying, fine, good faith exception. We don't need to go into the rest of it. Then we have a very interesting 6 judges, Judge Berner, Gregory, Wynn, Thacker, Benjamin, and Haytons in part. They claim that no search occurs when the government gets geofencing information in anonymized form. So when you get the initial geofence warrant and you go to Google and say, show me all of the devices that were in this area, and those devices have unique identifiers, that is not a search because it is anonymized. When that data is linked to a particular individual, a search occurs and a warrant is needed. So what they're saying is they disagree with other circuits, namely the Fifth Circuit, which claims that geofence warrants are categorically unconstitutional. They think as it relates to an individual person, when it's individualized towards each person to get more information about that person and that device, in that de-anonymization stage to reveal that person's identity, a warrant is required. And there was no warrant here. Therefore, Chatrie's conviction should be vacated.
Seems like a distinction without a difference to me.
In some ways it is, although I can understand it. Like there are 2 separate searches. You get the anonymized data, and then you have to do extra investigative work to connect phone numbers to an individual. And once you do that, that's where a search warrant is required because that's information about an individual, not just about the mass of devices that were within a certain area at a certain time.
So the distinction they're making is at which point in the chain requires the warrant.
Exactly. That is the distinction that they're making.
Okay.
And then you have one judge, Judge Gregory, just reasserting, even though Judge Gregory joined a bunch of other opinions, that the geofence warrant in this case is unconstitutional. Good faith exception should not apply. So for those of you mathematicians out there, we have a 7-7 split. This is just an interpretation of all of those opinions on whether a search occurred. There are 15 judges on the panel. I think I said 12 to 13 earlier. So we'll go with 15 judges. As a reasonable estimate.
Is there an official name for a group of judges? Is it like a gaggle of judges?
Like they have for geese or something?
Right. Yeah, like a murder of crows,
I think it's just a full panel of judges.
Okay, fair enough.
But we have one, Judge Diaz, who didn't express an opinion either way. So what that means is there's no majority opinion at all. We have 7 judges out of 15 saying this is a search for Fourth Amendment purposes, 7 judges saying there isn't, 1 judge punting on the question. So where does this leave the law in the Fourth Circuit?
Right.
Who the hell knows? And luckily for me and you, Dave, we live in the Fourth Circuit.
Oh, goody.
I don't think it's going to change my behavior because, I'm not one to go around robbing banks or committing other crimes. But that's not good enough for a lot of the civil libertarians out there who really, really do care about this stuff. And I'm very sympathetic.
So does the lack of a majority consensus put some fuel into the trajectory toward the Supreme Court?
I think absolutely.
Yeah.
If you combine the mess of this opinion with what we saw from the Fifth Circuit, which was a categorical holding that even with a valid warrant, geofence searches are unconstitutional. When you have that kind of divergence of opinion on such an important question, I don't see how the Supreme Court could choose not to weigh in on this case.
Okay.
I think given that the conviction has been sustained here, because that's what the district court held, I would expect that Chatrie's attorneys will petition for a writ of certiorari at the Supreme Court.
And that's the next step?
That would be the next step here.
Okay.
And if 4 justices are willing to take up this issue, then we'll get that long-awaited case where we can actually have some clarity on whether geofence warrants are constitutional or not. Because you can say a lot of things about this 124-page opinion, but the one thing that is definitely lacking is clarity.
So you've mentioned that it's been a while since we've had a Fourth Amendment case in front of the Supreme Court. Does that, I don't know, does that indicate that perhaps the justices would have a hunger for this sort of thing? Do they have an appetite for this, or am I reading too much into it?
It's hard to know whether they have an appetite for it. I do think in terms of the decision to take cases, it's really on an individualized basis. Like, is this important enough that we need some constitutional clarity? And B, is there a sufficient circuit split where we can't just say, what I say to my two kids when they're fighting, like, you guys just figure it out by yourselves. Come up with your own solution. So yeah, that's why I think they are more likely than not to take it. I don't think that has to do necessarily with the fact that we have this 6-year, 7-year drought on Fourth Amendment cases.
Yeah.
But no time like the present. And if they do grant certiorari in this case, it would probably be heard during the 2025-2026 term, which means we'd have to wait another year or so to have a solution to this problem. But I just think what this case illustrates is that judges are all over the place on this issue.
Mm-hmm.
And when that happens, that's when you generally see cases make it to the Supreme Court. It's not just that they have a fundamental ideological disagreement on something like, say, abortion,
right,
where you either believe side A or side B. Here, they are just all over the map, as we see by these 8 separate decisions accounting for 15 judges on the panel.
And suppose this does go to the Supreme Court, and it seems likely that it would, what could we hope for in terms of ultimate clarity there? I mean, we would not have the same sort of lack of consensus from. I guess there'd be a decision. Right?
There would be a decision. Theoretically,
there could be dissent. It could be a 5-4. It could be.
It could be 4-4, and then you have a 5th justice who's willing to uphold the conviction on the good faith exception, but is not willing to expound on whether this is a search or not. That would leave all of us very, very unsatisfied.
Oh.
And we'd have to find another case where people were well aware of the controversy, and in their individual circuit, they knew that these types of geofence warrants were unconstitutional. Law enforcement in the Fifth Circuit has now been warned that this is an unconstitutional practice. They do it anyway. Therefore, the good faith exception wouldn't apply, and you'd have a case where you couldn't just punt and say, good faith exception, we're done here.
I see.
So that would extend the process. The Supreme Court does do things like that sometimes. I'd like to think, just for our sake, we could have some clarity here.
Yeah.
Go through the text of Carpenter and figure out how much of Carpenter applies to the facts in geofence warrant cases. I think that's what would be most helpful.
Okay. Well, it's an interesting one for sure. We'll have a link to that story in the show notes. And,
interesting and very confusing, admittedly.
but stay tuned, right? Because there's
more to come.
More to come on this one.
Yeah.
And we can't keep going with this uncertainty, right? I mean, it is truly, it's an important issue.
Yeah, I mean, one of the reasons, if you look at legal scholars, they talk about the importance of stare decisis, judicial decisions, and our common law system as having that clarity so that potential criminal suspects know what the law is, law enforcement knows what the law is, we know what the ground rules are, and things get confusing and mixed up when there's so much confusion on those ground rules.
We'll be right back. What's the common denominator in security incidents? Escalations and lateral movement. When a privileged account is compromised, attackers can seize control of critical assets. With bad directory hygiene and years of technical debt, identity attack paths are easy targets for threat actors to exploit, but hard for defenders to detect. This poses risk in Active Directory, Entra ID, and hybrid configurations. Identity leaders are reducing such risks with attack path management. You can learn how attack path management is connecting identity and security teams while reducing risk with Bloodhound Enterprise, powered by SpecterOps. Head to specterops.io today to learn more. SpecterOps, see your attack paths the way adversaries do.
My story this week comes from the Washington Post, and this is, Apple getting more than a slap on the wrist.
Raked over the coals here.
That is probably a better way to say it. A U.S. district judge, this is Yvonne Gonzalez-Rogers, determined that Apple violated a 2021 injunction from the Epic Games lawsuit. And this injunction required Apple to allow developers to direct users to alternate payment methods outside the App Store. So what this is about is Apple has exercised tremendous control over the App Store. If you want to install an app, make available an app for an iOS device, the only practical way to do that without jailbreaking your device is to go through the App Store. And Apple imposes a lot of rules. There was an injunction against Apple that they had to loosen up some of those rules. Despite the injunction, Apple introduced a 27% commission fee on purchases made through external links.
I mean, at that point, you should honestly just admit you screwed up here, because when the judge said a 30% fee clearly violates is an anti-competitive action that violates our antitrust laws, and you come back with a 27% fee.
Yeah. That's
almost a slap in the face, in my opinion.
So the judge found that to be a willful violation of the court order. Judge Gonzalez-Rogers referred Apple and a top finance executive to federal prosecutors for potential criminal investigation, citing that the executive outright lied under oath to conceal Apple's defiance of the order. Ben, I mean, we often kind of roll our eyes about how big companies like Apple and their executives never face any sort of criminal worries that there's a fine and it's, basically the money they have in their couch cushions and they go on with business. This is stronger than that.
It is definitely stronger than that. Now, do I think we're going to see Tim Cook in handcuffs? No, probably not.
Yeah.
But this is very serious. So you talked about the change in the percentage fee, which I think is significant in that it's so obvious that lowering that fee from 30% to 27% when several years ago the fee was nothing, and then extending the commission for a period of 7 days after the consumer linked out of the app, that is just a blatant violation of the spirit of the holding from 2022.
Right.
The other thing they did is in that holding, the court prohibited Apple from denying developers the ability to communicate with and direct consumers to other purchasing mechanisms. So Apple said you can't link to your own purchasing page, whether that's through Google or through their own payment system entirely.
Right.
What Apple did is, at least according to this judge, they imposed new barriers and new requirements and increased what are called breakage rates with scare screens, static URLs, and generic statements. My interpretation of that, and you probably know more about this than I do, a scare screen is, are you sure you want to click on this dangerous link to this alternative payment system?
You are about to leave the App Store.
Dangerous malware will end up on your device.
Yeah.
Your phone may spontaneously combust.
Right.
So obviously, the allegation is that Apple is dissuading customers from using these alternative purchase mechanisms. And therefore, they are maintaining their anti-competitive revenue stream. The big question for me when I first saw this story is, well, what's the proof? And it seems like the court has been able to obtain pretty profound, interesting records just through document requests on what was happening internally at Apple. And according to the judge here, two things happened. One is that the vice president of finance, Alex Roman, when asked about Apple's compliance with the ruling, allegedly, at least according to this judge, lied under oath about their compliance. Internally, there's this guy, Philip Schiller, who had advocated that Apple comply fully with the injunction.
Yeah.
But Tim Cook, according to contemporaneous documents, ignored Schiller's advice and instead allowed the CFO, Luca Maestri, and the finance team to convince him otherwise. And when you look at the full record, and this is an 80-page order here, it's pretty compelling that Tim Cook chose incorrectly. and has made a conscious decision to really not comply with the injunction, which could subject him to criminal contempt. This is more than just excuse me, can you please try a little harder? This is you're in willful noncompliance, effective immediately. You are required to no longer impede developers' ability to communicate with users, nor are you able to levy or impose a new commission on off-app purchases. And we're serious this time.
Yeah.
You might go to jail if you don't do it.
Some quotes from the judge. She said, "This is an injunction, not a negotiation. There are no do-overs once a party willfully disregards a court order. Time is of the essence. The court will not tolerate further delays. Apple's continued attempts to interfere with competition will not be tolerated." Pretty direct.
Yeah, I'd say so.
So Apple has denied the violations. They say we strongly disagree with the decision, and they've filed an appeal to the Ninth U.S. Circuit Court of Appeals. How will that likely play out, Ben?
It's really hard to know. Ninth Circuit is a big behemoth. They have a lot of different judges. Again, you're going to have a panel of judges drawn. Who knows what the makeup of that panel is going to be? I think certainly this alleged noncompliance, even if they decided today to fully comply and take off the entire commission and allow users to communicate directly with the Epic Games folks in there about alternative payment methods, they've still kind of shown themselves to be resistant to injunctions from district courts, and that is going to reflect poorly on them as this makes this way through the appeals process. But I don't think we really have any idea on what the Court of Appeals is going to do. The Ninth Circuit, like I said, has a ton of judges. We might end up seeing the same thing that we saw in our previous story, where if you get an unrepresentative panel, then you might get an appeal that the full Court of Appeals hear this case en banc, might make it up to the Supreme Court. So that could take a while. In the meantime, while this is all going on, the judge here is threatening to impose criminal penalties, and the judge has the power to impose those penalties if the judge is convinced that Apple, despite this new order, is still not in compliance.
Yeah.
Even during the appeals process, that judge can levy those penalties.
Okay, so that's my next question is the judge is clearly saying we want no more delays, but is the appeals process inherently, by its nature, a delay?
It is in some ways. Once criminal penalties are imposed, usually you could appeal those criminal penalties right away, and then that would elongate the proceedings, even though those penalties can be imposed during the appeals process. So yeah, there are certainly delay tactics. I still think it's probably in Apple's best interest not to test this judge nor the Ninth Circuit.
Mm-hmm.
I think they've been playing with fire here.
Mm-hmm.
And the judge is telling them that they can't do that without suffering consequences. So,
yeah, I mean, it seems striking to me how direct the judge is with this. That, you know, the style with which this is written.
She seems legitimately angry.
Yeah. And unambiguous that what the judge believes has happened here. So, to me, that if you take that opinion and bump it up to the Ninth Circuit, it seems to me like that's a big hill for Apple to climb.
Right. The other thing that I think is noteworthy here is the record that's been accumulated. So the fact that they've had these document requests and evidentiary hearings, they have enough evidence to show that Apple knew what its obligations were and purposefully decided to thwart the previous injunction's goals and continued its anti-competitive practices. There's some evidence in the record that Apple believed the court wouldn't have the power, the wherewithal, or the desire to see through that Apple was complying with the orders of the injunction. So there's some I don't know exactly what it is, but there's some contemporaneous evidence out there that seems to indicate that Apple thought that the court wasn't really going to follow through on enforcement in a rigorous way and that they could get away with these half measures. All that's cited in at least the summary of the opinion is a 2024 evidentiary hearing on the subject. But, I mean, that's what's really serious here is you have a willful disregard. It's not just a notional disregard or like you disregarded one aspect of it or you meant to comply, you were acting in good faith, but the court is imploring you to do otherwise. This is a very serious violation, and it behooves Apple to take this seriously.
Help me understand the potential criminal issues here. I mean, I guess what I'm trying to understand is the judge has said that both Apple, the company, and an individual may be in criminal peril here. What's the difference of coming after a company with the size and the resources of Apple versus one of its individual employees?
I mean, you can hold them both either liable in civil court or you can impose criminal penalties on both. The penalties themselves, in most cases, are going to be different. But like you could impose criminal fines on the company and its shareholders, or you could hold the individual officers in criminal contempt. Both are options that are available to the judge in this case. So it's really just about who's getting punished. Now, if you're an officer, you're getting punished either way because you have a large share in the company and you're representing the company.
Right.
But it's much harder to put handcuffs on a company than it is on an individual. So that's just kind of, you're keeping your options open and being willing to punish the company itself versus punishing its corporate officers.
I see. All right. Well, we will have a link to that story in the show notes. And of course, we would love to hear from you. If there's something you'd like us to consider for the show, you can email us. It's caveat@n2k.com. Traditional pen testing is resource-intensive, slow, and expensive, providing only a point-in-time snapshot of your application's security, leaving it vulnerable between development cycles. Automated scanners alone are unreliable in detecting faults within application logic and critical vulnerabilities. Outpost 24's continuous pen testing as a service solution offers year-round protection, with recurring manual penetration testing conducted by CREST-certified pen testers, allowing you to stay ahead of threats and ensure your web applications are always secure. And that is Caveat, brought to you by N2K Cyberwire. We'd love to know what you think of this podcast. Your feedback ensures we deliver the insights that keep you a step ahead in the rapidly changing world of cybersecurity. If you like our show, please share a rating and review in your favorite podcast app. Please also fill out the survey in the show notes or send an email to caveat@n2k.com. This episode is produced by Liz Stokes. Our executive producer is Jennifer Iben. The show is mixed by Trey Hester. Peter Kilpie is our publisher. I'm Dave Bittner.
And I'm Ben Yellen.
Thanks for listening.